please put them in the Q&A box as you have them, so you don't forget them, and I'll be sure to address them. If it's something that we're dealing with in a current slide, I'll address it then. Otherwise, we'll hold them to the end. So without further ado, let's talk about the impact that Prop 19 is going to have on many of your clients and why they need to act now and how you can help them. So first, a little bit about me. Some of you are attending the webinar right now, may or may not be familiar with who I am. I've explained myself as a estate planning and elder law planning attorney, but I have a team that supports me. We have another attorney in the office, Hannah Farrington, and my awesome wife is the one that manages the ship. You don't see our virtual team. We are virtual mainly right now during COVID. And we always have had a virtual staff, and they support us, and Carolyn manages all of that at the office. So if you work with us before, you work with me or you work with Hannah directly in assisting your clients. But I'm coming to you today because I'm not just an estate planning and elder law planning attorney. Of course, I'm a husband and a father, and I'm a child and a grandchild, and all of these things that happen that we in life and the law that we talk to clients about all the time are personal to us because it's something that affects us personally. So there's my home team in the middle, and we have a larger extended family there. So family is really important to us at the firm, and we want to make sure that how we're protecting our family is being discussed with protecting our client family and your client family. And today, Prop 19 is going to affect many of our families, whether they're ours or our clients. And so because it's something that I think about for my family and my client family, I want to make sure that this good information gets in front of you. So what are you going to learn today? You're going to learn, of course, what the law is right now. We need to assess our point A before we talk about the changes and the solutions of how we get to a better point B. So what is the law right now? Because the law hasn't changed right today, it's going to change in the near future. So having an understanding of what the Proposition 13 law is, what the pre-Proposition 19 law is going to be important. Knowing what Proposition 19 actually says. We can't know its impact unless we know what the language of the law is, what we know, and of course, what we don't know. We're going to go over some case examples because examples are always helpful. I want to highlight who of your clients you should be concerned about in the scope of who should be concerned about this change. We'll look at some pitfalls and problems in both the application of the law as well as people trying to put some solutions together now, things that you should be aware of for your clients. And of course, we'll look at some good possible solutions for your clients and what that looks like. And I'll share with you at the end of our time today how your clients can easily connect with us so that we can assist them with a detailed analysis of their situation and recommend some possible solutions. So, of course, you're talking to an attorney, have to have some disclaimers, right? This is very, very important, and I want you to understand, of course, this is not legal advice or tax advice on this webinar. I'm going to be giving you my perspective of the law, what I've learned in studying the law, the conversations that I've had with people moving forward. And I'm going to share all that with you, but I'm not giving you any legal advice or tax advice because everyone's situation is very specific. This is the impact of Prop 19 is situational. In addition, it's dynamic. So there are changes that are happening on a daily basis and how we look at this, number one, but also the Board of Equalization is slowly coming out with some information of how they're going to interpret things. There's a letter that came out last Friday, and we're going to be looking for further direction for them on the application of this particular proposition because it's really confusing. It's confusing for them too. So this is, again, a dynamic situation. So if you're listening to this now and it's weeks from now, you may look to see if I've done a supplemental webinar to make sure that what I'm saying now is still what the current analysis and situation is. There's no magic bullet that's going to fix all of the situations here. We're humans and we want to look for the easy button, something that's going to fix everything. Unfortunately, there is not going to be a magic bullet here. Again, the solutions are very situational for clients. There's going to be solutions available And there's going to be solutions that would be great, but they're not going to be available for everybody. In fact, some situations might result with no action needed to be done. So it's important that there has to be a detailed analysis of every situation. And of course, this affects only people that own real property in California. So if you're listening to this and you have clients that have property in other states, Proposition 19 is a California law. It's only going to affect and impact property tax here in California, not in any other states. So what is the law right now? Well, the law right now involves a bunch of different propositions. So all those other props. We're hearing about Proposition 19. That is the new proposition that puts changes to Proposition 13, Proposition 58, and Proposition 193. These are the propositions that currently govern the property tax paradigm in California. So Prop 13 is the original proposition that set forth the new assessed values and how the counties were going to tax the property. Proposition 58 is the quote unquote parent-child exclusion. Proposition 193 is the quote unquote grandparent-grandchild exclusion. And they all converge on each other. And we'll come back to this diagram here. I'm a picture guy. I'm a visual learner for those of you that know me or work with me. And estate planning and tax is a very complicated law, and it's best explained with visual aids. So here we have Proposition 13 is kind of minimized if we look at this example with the ovals of Proposition 58 and Proposition 193 on top of it, because those are exclusions that prevent the full impact of a reassessed tax that Prop 13 may require. So looking at that a little bit closely, what does Proposition 13 actually say? Well, it's a tax on an assessed value, also known as a base year value. So when people say my Prop 13 base, that means that at the time that they acquired the property, their county assessor's office assessed a value for that land based on the fair market value. And over time, it can be increased if there are improvements on the property, and on an annual basis, the county assessor can increase it by no more than 2%. And we see that every year as our property bills increase by small amounts. It also can be increased, that base value, when there's a change of ownership. And the change of ownership is when you sell your house or you purchase one, for example, you gift it to another person. That constitutes a change in value. And when there's a change in value, Prop 13 requires that there be a reassessment of the assessed value of the land at fair market value rate. So when you purchase a property, that's why your property tax is higher than the property tax that you had formerly on your former property, because there's a reassessment. And that is the law. Now, there are some exclusions to the change of ownership. So there will not be a reassessment if you fall into the brackets of those exclusions. And so those exclusions are the Prop 58 parent-child exclusion and the Prop 193 grandparent-grandchild exclusion. Now, both of those exclusions are very similar in their application. So it deals with a principal residence. There's no value limit. So a parent can pass to a child their principal residence, either in life or in death, as a gift, and there's not going to be a reassessment because of this exclusion. It also includes up to $1 million of assessed value for other real property. Now, this is the current law today. So a parent can pass their home and up to $1 million in aggregate of the assessed value of all other real property, that being a vacation home, it could be commercial property, rental property, and it's the assessed value. So if a parent purchased that property years ago, that assessed value is certainly going to be lower than fair market value. And by the way, it's per parent. So a married couple has $2 million worth of this exemption on other real property. So it's a real benefit for not just the home at any value, but any of the other properties that they own, which today's dollars might be very high in fair market value. On the assessed value, are a lot lower. And there are situations where parents can pass homes and other additional parcels of real property with no increase in property tax to their children because of the exclusions. Now, in order to do it, you have to file something with the county assessor's office. It doesn't happen automatically. And this is a key point here, both for the current law and moving forward that we're going to talk about today. There has to be some affirmative steps. And we've seen problems in the past where children or grandchildren just assume that these exclusions happen and the paperwork's not filed, and they have major questions and frustration later when the assessor's office reassesses the property despite them falling into one of these exclusions. So you have to file the paperwork, and it has to be filed within 3 years of the transfer. So there's a time limit on this exclusion. In fact, we worked with a couple families in the past where that was a real issue, where the children didn't take any action after the parent passed away, and we were 5 or 6 years down the road, and we were outside of that 3-year window, and that created a very problematic scenario. Because the assessor's office could do a partial reassessment. So timing is everything. If you remember nothing from the conversation today, timing is everything. And doing something now rather than later is important. So the grandparent-grandchild exclusion acts very similarly to the parent-child exclusion, but it has a limited application. So this one we don't see very often because the application is from, the transfer has to be from a grandparent to a grandchild, and the grandchild's parent, who is the child of the grandparent, has to be deceased. So we can't have any intermediate child. So it can't be grandparent who has a child that's living and that child's child, their grandchild, they want to pass it to. If they do that, and their child's still living, then they cannot fall under the exclusion. There will be a reassessment. So that's why we see a limited situation where we have deaths of children but surviving grandchildren. In those situations, yes, Proposition 193 will be helpful. Also, little sidebar here, we've also seen problems where the grandparent passes to their child, and then the child turns around and passes it to their child in very short succession. That's going to be flagged by the assessor's offices as an end run around this exclusion. So you have to be careful. So yes, there's a parent-child exclusion, and you're doing that parent-child to parent-child, but if you do it in quick succession, the assessor's office is just going to say, you're just doing a grandparent-grandchild transfer, and it's not falling under the exclusion. So you have to be careful under current law. So those are the 3 propositions that we're dealing with under current law. So I thought it would be helpful to kind of see what Proposition 19 says then, right? So, actually, let's do this. I'll do a little example on the current law first, so you can just see the application. So here in our fact pattern, parents seek to give their home and a rental property to a child. The home has a taxable value of $2 million, and they pay $22,000 of property tax. And that's based on a assumption of 1.1%. We pay a minimum 1%. Some of us pay more than that, depending on the city that we live in and the bonds that are attributed to that. This is just an assumption on an average of 1.1% property tax. Now the home has appreciated to $4 million. So the taxable value was for property tax. Remember that assessed base value is $2 million because that's what the parents purchased it at originally. Now the value, the fair market is $4 million. Obviously we see appreciation of $2 million. They also have a rental property worth $500,000 when they purchased it. So they have a taxable base of $500,000. Its fair market has increased to $1 million and they pay property tax bill of $5,500. So under current law, this is very favorable for the parents to gift to their child in life or in death. And so we'll see that the child, in addition to inheriting the property, is going to inherit the parent's property tax bill. There will not be a reassessment on the principal home, the primary home. In addition, on the rental property, because the assessed value is under $1 million, and certainly because here in this example, there's 2 parents, so under $2 million, there's not going to be a reassessment with that property either. So the child in this situation is going to be able to inherit the properties and also get the same tax bill that their parents had on that property. So it's not going to be an increase in property tax for the child here. Of course, annually, that small amount of course, because that's what was happening with the parent. So like the example I use is that you inherit the parent's property tax bill, which includes the increases on an annual basis. So this is very, very favorable from a property tax standpoint in transferring to the parents. So let's see how Proposition 19 is going to disrupt this. So here's the, oh no, now what? So here's what Proposition 19 says: the good, bad, and indifferent, right? So like with many laws, there's some good parts and there's some bad parts. So we're going to talk about the bad parts first, because this conversation today is about the property tax impact for your clients and why they need to act now, not necessarily the benefits to potentially your clients. So we were just talking about the exclusions under 58 and 193, the parent-child, grandparent-grandchild exclusions. So Proposition 19 puts a limit on those exclusions. It basically just eviscerates them, takes them away, and it leaves a very, very, very small exclusion. So now instead of being able to pass down or gift out the principal residence at any value, there's going to be a reassessment on that transfer, whether it's a gift or whether it's a sale, whether it's inheritance, now in the Proposition 19 timeline. And again, this isn't today. I got to stress this. This is February the 16th and later. All right. So right now, we're just talking about what Proposition 19 will do. All right. And that's important because we can still take advantage of some solutions here. So again, there's going to be a reassessment when mom and dad or grandpa and grandma want to transfer their principal residence to a child or grandchild. Unless, and this is a very small unless, it's classified under a family home. And that family home is a specific definition here. So, and that's what proposition changes. So it's just not what we call principal residence. They describe a family home as being a principal residence for the transferor and the transferee. So your child or grandchild has to claim your principal residence as their principal residence. Now, it doesn't have to happen immediately. They have up to 1 year to claim it. Now, again, it can't be a rental property that you pass to your child or grandchild, and then they go ahead and move into it and claim it as their principal residence. That's not going to count. It has to be the parent or grandparent's principal residence and then transferred and claimed as the principal residence of the child or grandchild. And how do you do that? Well, you have to file for your homestead exemption on your taxes. That's $7,000. That's $70 that you save. That's the homestead exemption, and that's how the assessor's offices are going to be tracking, because you can only claim one residence as your principal residence. You can't have multiple. So they're going to know when things transfer. Also, the other way you claim it is if you have a disabled veterans exemption, which for those of you that may not know, a little side note, very important savings for those clients of yours that are 100% disabled through the VA. They can qualify through their county assessor's office for a very significant exemption on their property taxes. Now, it doesn't eviscerate it all, but it does reduce it. So that's a little side note that's super important. So here we have the family home having to be claimed within that 1 year in order to get the exclusion, but the exclusion isn't for any value anymore. It's for a limited value. So we're going to see that there's going to be a transfer of principal residence from the transferor to transferee. That's still going to trigger a partial reassessment because there's a new value test that is going to be applied. And I tried to capture an equation that could be helpful to remember here. So if you're looking at the time of transfer, the fair market value of that property, if it's greater than the sum of the base assessed value plus $1 million, then there's going to be an assessment on the overage. So that, like I said, there's going to be many occasions where a child or grandchild is going to receive a principal residence and claim it as their home, but they're still going to pay higher property tax, even under Proposition 19. And the kicker, all other real property is going to be reassessed. So all those vacation homes, rental properties, they're all going to be reassessed. There's not going to be an exclusion for any of them, no $1 million exemption for them. All right, so that's all gone. So it's going to be a major impact. Now, that's all the bad stuff about Prop 19. The good stuff is that there's going to be portability of the Prop 13 base to any new property anywhere in California for people that fall under special classifications. So you have to be 55 and over, disabled, or a victim of a natural disaster, wildfire. Then you can move to a different place in California and minimize the property tax increase that you would otherwise experience under the current Prop 13 laws when you buy a new property. So this is beneficial because now that is restricted to intrastate counties on a county by county basis. So you can move within a county and be able to do this, port your Prop 13 base value, but going to a different county, you're most likely going to be restricted currently. So Prop 19's open the doors and say, hey, we're not going to have this disparate application by county. We're going to allow everyone to move within the state of California and take their property tax base with them. But it's not, you get to swap it out and take it with you fully. There still could be a partial reassessment. So if the fair market value of the property you're purchasing is more than the assessed value of your property, the overage will be reassessed. So there's going to be another webinar on that. It's more complicated, and the value date on that of the assessments is April 1st. So that's also confusing. We'll talk about some of the pitfalls. People looking at Prop 19 taking effect April 1st. That's not true. It takes effect on February 16th. Just the calculation of assessed value for the portability part, that's going to be measured April 1st and later. And there's a lot of confusion about some of those calculations as well, because again, Proposition 19 is confusing. It was a proposition. It wasn't passed by a legislature. There's a lot of unknowns and questions that the Board of Equalization has, in addition to all of us. So there's a lot of lack of clarity here on a number of things. But we'll address that, the good part, in another webinar. Looking at our diagram again, so here is the current pre-February 16th, 2021 application of the property tax paradigm. We see how favorable Prop 58, Prop 193 is, but now here's the impact, right? As we just heard what the law actually says, here visually is the impact. The Proposition 13 is going to reclaim a lot of dollars, and the benefit of Prop 58, Prop 193 is going to be reduced. Right, so there's going to be more money flowing into the county assessor's offices because property transfers are going to be reassessed, all of them with very limited exceptions that we saw. So we're going to see more reassessments on transfers of property that occur on February 16th of 2021 and later. Transfers mean sale, gift, inheritance. So if the transfer, the date of the transfer of a death on a gift or a sale occur on or after February 16, 2021, there's going to be a reassessment, which means bigger tax bills for children and grandchildren. And due to the lack of clarity on some of these things here, we're also going to see a lot more litigation on this. I just have to expect that there'll be more administrative hearings with the county tax assessor's offices and further litigation beyond that, I'm sure. We're hoping to see some weigh-in from the legislature to kind of interpret some of these things. Now, Proposition 19 is amendment to the state constitution. So legislatures can't legislate away Proposition 19, but they certainly can pass legislation to interpret some things. For example, the start date of it. Right now, that's February 16th, but we could see a situation where the state legislature passes a law that extends out that date. And that we're hoping for that. And if that's going to be beneficial for you, then I would encourage you to write your state representative to let them know of the impact and the benefit to have maybe a little bit more time before the imposition of this. Remember, they can't write it away and prevent it from coming to pass, given that it's a proposition, but they can certainly pass some legislation to delay it, to give everyone a little bit more time, certainly in pandemic, to understand the true impact and put good solutions in place. So looking now at an example, I want to just show you again, example how the family home can be reassessed in the future. And these examples I always find very helpful, right? So here is a single family residence. Base year value, $425,738. All right, pretty kind of commonplace. Many of your clients probably have a base value like this. Well, the parent dies March 1st, 2021. So after the February 16th start date of the new law. They were there was the principal residence for both the parent and the child. So here we have a child that was either living with the parent or they moved into the home after the parent passed away. So they're claiming it as the principal residence. On the parent's date of death, property has a fair market value of $1.75 million. So this is a really good cross section of a lot of property here in Orange County, right? So this is what is going to happen and how they're going to factor the new property tax rate. So the base value was $425,738. So that was generating the tax bill. So it was a low tax bill. Well, the child unfortunately isn't going to get the same property tax bill that the parent had. Because if you followed this this math here, and I didn't tell you there was going to be math. If I said there was going to be math, I don't know if anyone would show up on the webinar. So we did the math for you. So if you just follow this math here, under Proposition 19, you'll see that there's a difference, right? The fair market value is higher than the sum of the assessed value plus the $1 million exemption. So the overage is going to be the new base year value. So the base year value is going to be $750,000. That's what it's going to be taxed on. So the child's going to see an increase in property tax. This example is a smaller increase in property tax, but even the amount that it increases here, depending on who the child is and their economical means, that might be a backbreaker. And we can easily see other situations where that increase, even on the family home, is going to be much more significant. Think about your clients down in some of the, other areas of Southern California, down by the beach. I'm talking to clients that have homes on the peninsula and Balboa Island. Those homes appreciated a lot. So that difference in the fair market value is huge. So the new, even on a partial reassessment, that partial reassessment is going to be large dollar amounts. And if you have a situation where you want your child to live in your home, they need to live in your home, they want to live in your home, they might not be able to afford to live in your home now, even under Prop 19, because the increase on a partial reassessment is going to be huge. And here's a great question that came in that's really appropriate to what we're talking about right now. If parents pass and give the primary residence to the child, but the child does not claim as a primary residence, will the property tax base be fully reassessed? Yes. So in order to get the new Prop 58 exclusion, then you have to claim the parent's principal residence as your principal residence. If you can't claim that within the year, sorry, you're out of luck. Then you're not going to be able to claim the exclusion, and then it's going to be fully reassessed. Now, I should say a little side note that the $1 million exemption here on the family home, they're going to readjust that starting in 2 years on an annual basis, a small percentage. So that exemption will increase very minimal amount from 1 million upwards. And the idea, of course, is property is appreciating, so they want to keep track. But as we know, property in Southern California, of course, is going to be, in many parts of California, is going to be in excess of the amount that they're going to increase it. That's why this Prop 58 and 193 were so powerful, because property is appreciating at greater values than the amount that they can increase on an annual basis, that 2%. Property is increasing 4% or higher on an annual basis. And conservative 4%. You just look at your own property and look at what it was worth 10 years ago, even going through the recession to now, the increase, you're on average 4% appreciation. So there's going to be partial, there's going to be reassessments. There's going to be reassessments whether you can qualify for the exclusion or not on a family home because of that. It's just going to be a greater impact if you can't claim it as a principal residence. And another question is, well, what if you have more than one child? What then? Well, that's unclear. So do all children have to claim the home as a principal residence in order for there to be the exclusion? Or does the exclusion only apply to the percentage of the share of the home that is inherited by the child that moves in and claims it as a principal residence? So think about it. There's 3 kids. Parents leave their home. They leave it in an estate plan. Everything's divided equally. Now, each child has a 1/3 portion of the principal home. Only one child wants to move in. because we all know that all 3 kids aren't going to move in that house. That's a very, very rare situation. It's going to be one child that moves in the house. The other 2 children aren't going to want the house. In fact, we see those situations now where children are they're trying to buy out, siblings are trying to buy each other out because they don't want any part of the home. Only one of them wants to live there. So what about that situation? Well, that's an interesting one. That's one we don't have clarity on yet, but I can just surmise, being conservative in my approach here, thinking about it, that all of the interested parties will have to claim the exemption in order for there to be a full exclusion of the property tax reassessment on the family home. So if mom and dad leave their estate plan to children and grandchildren, children, grandchildren, other family members, other people, it can get really confusing, and there might be some missed opportunities because on exclusions. So it's really, really important that people's estate plans are looked at in order to consider all these things. Okay, under Prop 19, let's see how our example before of the parents that wanted to leave their home in the rental property. So going back, remember, those parents had a very favorable situation. They could leave their home and the rental property to their child, and there was going to be 0 property tax reassessment. But here, under Proposition 19, here's the impact. It's going to change. So let's assume the child's going to use the home as a principal residence. Only the first $1 million is going to be exempt. So the end result, we're going to see a new property tax bill, $33,000. Going to jump $22,000 to $33,000 under the partial reassessment. And the rental property is going to be reassessed on the fair market value of $1 million now, because none of that's going to be exempt. And so there's going to be a higher property tax bill that's going to effectively double, right? So there's going to be a net here between the properties of an increase in $16,500. Now that's an increase, right? So that's not the full property tax bill, but that's the increase that the child's going to inherit after Prop 19. So remember I said it might be too expensive for your children to inherit your properties. They may have to sell them even if they want to keep them, which is damaging, particularly if we have an income earning property. So a little graph here on that example, also helpful. You can see a little chart here kind of playing out in that situation that we talked about. Before Prop 19, you see no property tax reassessment. After Prop 19, we have the principal residence being used. You have an increase of the $16,500 that we talked about. But like with the question that came in, well, what if the child did not or could not claim the principal residence as his principal residence or her principal residence? Well, now we have a full reassessment on all property. Now the increase for the child goes up to $27,500 a year. Remember, that's a year. So huge impact over time to the children. And I keep saying children. Remember, the grandchild exclusion and the Prop 19 changes to it apply to that one too, but it's a very limited situation. So more likely we're going to have the parent-child situation, okay? So who needs to be concerned, right? So it's like, wow, this just hit me across the head. I can consider a lot of people, a lot of clients that I have of this being an issue, but I want to help you. I want to help you better identify which one of your clients this could be a real problem, because I can stand here and say, well, everybody, this affects everybody, so we should just assess everybody. We really have to do a triage right now. There is a tidal wave of effect in a very short time period to help, right? So we have to do triage. So here is a list of people to look at where this could be an issue. So the first, and this is an easy starting point in our little decision tree on how to help clients. Find out if the property that your current clients own is actually going to be owned by their children after they pass away, right? So what do I mean by that? Well, a lot of times our clients have assumptions about what their children or grandchildren are going to do. Oh yeah, they'll do this or that. But if you actually talk to the child or grandchild, they have a different vision of what they're going to do. So if the situation is mom and dad pass away and leave their property to their kids, and the kids are just going to turn around and sell it, and they have no intention of keeping it, then Prop 19 isn't a big deal as far as the kids are concerned. So mom and dad really shouldn't be motivated to be doing anything, right? So remember I said some of the outcome in this can be solutions, do nothing. Maybe mom and dad are more concerned about being able to port their Prop 13 base value somewhere else in California. They're thinking about moving. So your clients that want to retain the ability to port their base value somewhere else in California, then that the Prop 19 problems aren't really their problems. They have benefits. So these are things, that's the initial starting point that I work with clients. What is the outcome? What is the goal of the property, both from the parent, grandparent, and the receiving child, grandchild? Good things to have. Of course, when we're thinking about income earning property, rather than principal residence, there's a strong likelihood that that's going to be kept, right? And there's families that have kept properties in the family over generations, and under the old, under the property tax paradigm, under Prop 13, they have been able to keep it in their families without having a property tax reassessment with good planning. That's going to change now. So for families where that property is going to be kept, or maybe they don't use, the child or grandchild doesn't use it as a principal residence, but they recognize the income earning potential and they want to keep that property. For example, the properties in Balboa Island. I'm talking to a client, Balboa Island, bought the home decades ago, and it is increased in appreciation at an insane rate. And the children may or may not live there, but they certainly want to keep it because they want to rent it out. And what they will be able to rent out that property for is certainly going to eclipse the property tax. So they're going to be able to afford the property tax and still have some coin in their pocket. So it's not a bad deal for them to keep that property, even though they're not going to move into it as the principal residence. And of course, we can do that analysis with any rental property in California. If your client has a child that is living in another property as their principal residence, they kind of have another home, a second home, and they're letting their child live there rent-free or at a reduced rent to kind of help them out. Maybe they have some income earning issues or whatever the problem is, or they're just being kind. They were helping that child out. That is definitely somebody that we're going to want to talk to, because Prop 19, after February 16th, any transfer to that child, mom and dad die, that home goes to the child because they say, hey, we're letting them live there now, and then we're going to let them keep the house after we die. That's going to be our gift. Well, it's going to be a real painful gift because they might not be able to live there anymore. Because the property tax bill is going to shoot up, and they might not be able to afford to live in that house anymore. So it's really not going to be a gift or benefit for them. You're not going to be leaving them with a roof over the head. Sure, they'll have the value of the sale of the house, but it might be a better situation for them to actually have the house because they won't be able to qualify to get a similar type of house depending on their economic means. So that's a person that definitely needs to be concerned. Certainly people that have low cost basis, they've owned their properties for a long time, whether they have rental properties, vacation homes, or they just have a principal residence. That embarks a conversation here. People that have homes in QPERTs, Qualified Personal Residence Trust. This is a specialized trust that allows parents to gift to others, generally their children, their homes, and get it out of their estate. So when they pass away, those homes aren't in their estate for purposes of estate tax. So it's a tax savings tool from an estate tax planning perspective. However, the challenge here when it comes to property tax and Prop 19 is that the change of ownership for those trusts don't occur until the term of the QPERT ends. So, and generally those terms are kind of lengthy. So your client may have put a home in a QPERT years ago, and it's still within the term. So the trust still exists. And in that situation, that's a problem, because when the term is going to end after February 15th. So law goes into effect February 16th. So if the term of the QPERT ends February 16th or later, then that's when the change of ownership occurs. And so there's going to be a property tax increase at that moment, because that's when the transfer happens from the QPERT fully vested to the child who's the beneficiary. And then the child's going to have an increase in property tax. And that's going to be a problem. And now the whole purpose of that strategy was just to get it out of the parent's estate so that they can avoid the estate tax. They can save the 40% on the estate tax on that property to their kids, but they really want to live in that house. So the way it works is that they put it in trust, goes at a certain term, and when the term ends, it now really belongs to the child or children, and the parents just pay rent to the children. and that's ability to get that money out too, because that's rent money. So that's just money that's not sitting in their bank in their estate when they pass away. So it's a great estate tax savings tool. The problem is now parents are going to live in the home, and the home is going to be charged with a reassessment and pay higher property taxes than they were paying before they did the QPERT. So QPERT might not make sense anymore. Maybe it still does, but we need to do an analysis, right, to see which is the worst evil to avoid. So, but that's only going to work for people that are still in term. So if the QPERT term ended already, they've probably already taken advantage of the Prop 58. For those who the term's going to end before February 16th, well, they better rush out and hurry up and file those exclusion forms so that they can take advantage of the exclusion. So real problems there. So people have QPERTs. That's a great conversation to have. All right. Anyone who is a trustee and an incomplete trust administration. So if you're the trustee has to distribute property, homes, they have to do a change of ownership with on the title during the administration, and they need to file an exclusion form. In fact, in the how we handle administration, sometimes we delay that recording so that it doesn't trigger a question by the tax assessor's office because we're not clear on how we want to distribute that property. Maybe we're looking for a loan to equalize the property so siblings can buy themselves each other out. And so we're kind of playing a waiting game. Well, we can't play that waiting game anymore because we wait and then don't do the filing until on February 16th or later, then the tax assessor's office may reassess those taxes. Question, right? The transfer really occurred before because mom or dad died. And that's why we're doing the trust administration. But we file on February 16th or after. Is there going to be a reassessment? Don't know. Why risk it? We should file before so there's not a question of whether they're going to measure the time based on the date of the transfer or on the date of the filing. So like I said, I've had clients that come to us later. We're helping them with administration, but their parents had died years ago. Any of those situations need to file the forms right away. If you have a client that's a widow or widower, likely they have what's called an AB or ABC trust. So that type of planning was very, very common years ago when the federal estate exemptions were much, much lower. They're $11.58 million today, those exemptions. Most people don't need to structure their trusts in this format for purposes of estate tax planning. There are other reasons to do it, and it might still be good planning for those reasons, but not for estate tax planning purposes. Many people that we talk to were doing estate planning reviews that have trusts that were set up years ago. That is the only reason why they set it up that way. It's for estate tax planning purposes. Because in 2004, the exemption was 1.5 million, for example. Many people would have had a need to do this type of planning then. Not so much now. Problem is that when the spouse passed away, that created these other subtrusts, which then often fractionalized interest in their properties in between these trusts. And if anything's in a bypass trust, then they're stuck. They probably have a restriction that doesn't allow them to transfer that anywhere else, and then they have to wait to transfer it to their children until the surviving spouse passes away. And if that second death happens on or after February 16th, boom, we have a problem. There's going to be a limited ability to claim an exclusion. So children cannot claim an exclusion today if they have a surviving parent because both parents haven't passed away. So there's things that we can do. We'll talk about solutions in just a minute. There's things that we can do, but we have to do them before February 16th. So that is definitely something to look at. Ask your clients what type of trust they have. If your clients are wartime veterans or surviving spouse of a wartime veteran, they need to be concerned because some of the solutions that they might want to embark on are going to impact their ability to qualify for important VA benefits. So it's a great conversation to have now because if they need to take advantage of a solution that's going to require transferring property, then they have to do it in a very special way and they better be aware of the ramifications because again, you don't want to be rushing from one frying pan to another and try to take a benefit of lowering property tax for your children and grandchildren only to disavow yourself of important benefits that you need now for your care. Same with Medi-Cal. Those clients that have properties that are held in LLCs and the LLC did not purchase the property originally. Now, no, the LLC did not purchase the property originally. So if the LLC did purchase the property originally, then Prop 19 is not going to change that. There's definitely great ability in that situation to avoid a property tax reassessment due to the change of ownership rules. But the LLC had to have acquired the property originally. So you can't have a situation where a client owned it and then transferred to LLC, and or says, oh, it's an I want the LLC to get it out of the LLC and then reacquire it or something like that. It has to be acquired originally. So a lot of people have property that they purchased originally, then later they created an LLC. That's still great planning for liability purposes, other purposes. But here for the property tax issue is problematic because those properties aren't going to qualify for any exclusion, number one. It's not a parent-child exclusion. So there's going to be, and they're not going to be able to benefit for some of the other exclusions if the LLC purchased the property originally. So there might be some planning that your clients want to do in regards to those properties that are currently held in LLCs. At least it's a good conversation starter. So these are the primary people that need to be having the conversations. Like I said, everyone should be having the conversation, but since we can't help everyone due to the time constraints, these are the people that need to be having the conversations. So pitfalls and problems of a quick claim. So you might think, all right, so Kevin, I get it. We got to rush out and file these Prop 58 193 exclusions before February 16th. So in order to do that, we have to effectuate a transfer. Isn't the easiest way to do that just quick claim it? I'm just going to quick claim it. You know, some people call it quick claim because it sounds like it's something you can do very quickly, which is true. You can do it quickly, but in reality, it's called a quit claim deed. And that just means that you're passing interest in the property. Other states call it a warranty deed. We actually call it a grant deed transfer because you are passing the ownership and warranties in the grant deed transfer. It's the same thing. So people say quit claim deed. That really means legally a grant deed transfer. And that is a potential solution. It's a potential solution, but we need to slow down. All right. We need to slow down before we're going to rush out blind, thinking we're going to save some money for our kids and grandkids. And meanwhile, we'll step in a big pothole, right? Just like this picture shows. We want to avoid that. And here are the pitfalls in doing a rush quick claim. People are going to confuse the dates. Well, as long as I file by February 16th. No, that's not right. If it's February 16th, you're already too late. Well, I have until February 16th. So February 15th, I'll do it by February 15th. Sorry, you're going to lose because February 15th is a holiday. It's President's Day. County offices are going to be closed. You're not going to be able to record anything. Can't record anything on the weekend before that. And some offices are going to be closed on that Friday as well. So really, it's February 11th, right? So you've got to understand what the dates are. And like I said, there's this other April 1st date that doesn't apply to when the law goes into effect. So if people wait till April, they're way too late. So we talked about QPERTs and some of the pitfalls there, and try to undo a QPERT instead by doing a quick claim. One of the problems that's going to come up is on the capital gains tax side. So again, we got to manage the impacts of different types of taxes. You can do an end run around property tax, do a solution now, but if you do too quickly without kind of really going into a detailed analysis of what other ramifications there are when it comes to taxes, it's going to be a problem. If you transfer a property, quick claim a property today, you're going to forfeit a step up in basis for the receiving party. So you transfer it to your child today, that's going to forfeit the step up in basis. They get what's called carryover basis. So whatever the cost basis is on the property that you have, they're now going to have. This has nothing to do with assessed land value for Prop 13. All right. I know it's confusing. So when I talk about cost basis, that's the measure that the federal and California governments are used to tax appreciation, gain. Capital gains are measured by the difference between fair market value and cost basis. And that's otherwise known as profit. Think about profit. Governments like to tax profit. That's what they're doing here. So what we want to do is give our children and grandchildren a basis step up. So that measuring stick is not going to be the original purchase price of our property, but it's going to be at the fair market value on our death. So that's why it's better to gift in death than gift in life for purposes of capital gains tax savings. The same is here. So if you're rushing to avoid property tax by doing a quick claim deed, you might just be giving a bigger tax bill to your kids or grandkids later on down the road when they go to sell it. And that tax bill will be more harmful than the property tax that they save on an annual basis. So we have to do a detailed analysis. Rushing out and doing quick claims when you have bypass trusts. So people say, oh, well, it's a bypass trust, I'll just go quickly record something. Well, if done improperly and against the rules of the trust, that can be undone later. And when it's going to be undone, it's going to be undone after February 16th when people find out about it. When do the people find out about it? When you die. And things don't go according to plan. People unwind what the transactions and say, hey, wait a minute, mom or dad wasn't allowed to do that out of the bypass trust because they did it improperly. In order to do it correctly, you really need a modification from a court. And then you have a court order, then it can be done. But that takes time. So if you rush out and do a quick claim, it's going to be undone later because it's going to be an illegal transfer. So it'll be undone. And then there'll be a property tax reassessment. You'll miss an opportunity. So do it the right way by getting the court involved to do a modification. So rushing to record a quick claim deed is going to create a lot of problems. So, and here are some of those collateral consequences for that we haven't talked about when it comes to the rushing for a quick claim deed. Some of them we have, the bigger tax problems. But some of the others, of course, are just you don't own the home anymore. So that exposes you, the parent or grandparent, to the liabilities of your child or grandchild. You can lose the home. You can get kicked out of your home. Why? Well, child or grandchild says, too bad, we've changed our mind, we don't like you, you're out. Okay, that you might say that's not going to happen. Maybe it does, maybe it doesn't. But perhaps maybe more realistically, that child or grandchild goes through a divorce, has a lot of debt and gets sued, gets in a car accident and gets sued. And then all of a sudden, now what was formerly your home is their property, and then is subjected to the creditors. And they don't mean to kick you out, but the creditors do. Or your child or grandchild dies before you. Well, what's their estate plan? That's another way that the home can get ripped out from under your feet, just in a simple quick claim transfer. So we got to coordinate estate planning when it comes to that, of course, if you're going to do something like that. We have already talked about tax problems, disqualification for Medi-Cal and VA pension. You transfer your home or another property, that can impact because there's look-back rules and penalty periods, and you can inadvertently trigger a very long penalty period. And when you need that benefit, even if you don't need it now, you need it years from now, they're not going to give it to you because you're still riding out a penalty period. But doesn't mean you can't do it. You just got to do it in a special way, and you got to do it with guidance. You could forfeit the good part of Prop 19. Like I said, what if you want to move? You want to retain that right. You can give that up. And there's a possible loss of the 121 exemption on capital gains in the sale of a principal residence. So if you're living in your home and you gift it out in a quitclaim deed to a child or grandchild for purposes of avoiding Prop 19, later on it's important for you to sell the house. Well, guess what? You just lost out on being able to claim a $500,000, $250,000 exemption in the capital gains increase. Maybe you still get that if the child or grandchild lives with you, but if not, then that's a problem. So you got to be aware of that. And mortgage and reverse mortgage complications. So you transfer a property, you still have a mortgage on it, that could trigger an acceleration clause on it. You got to be aware of that. And then if you need to use the equity in your home for a reverse mortgage, then you got to be aware of that too, because now you're no longer the homeowner. And you're still living in the home. Nothing's changed from that perspective, but you're no longer the homeowner. So now that reverse mortgage is not gonna be an opportunity for you. So you gotta look at these things. So this situation is complex, right? Because it involves a lot of different moving parts. This is just the tax. I didn't overlay onto this thinking about collateral consequences that don't involve tax. This is just from the tax perspective. We got to analyze all of our clients from their property tax liabilities, from the transfer tax, which is the capital gains tax, and the estate tax liabilities, and look at the impact of each of these things. Now, many of you, the estate tax isn't going to be an issue for a lot of your clients because of the 11.58 exemption right now, but that can change. That can change this year with Congress. It could change in the future. We know it's going to change at the end of 2025. It's going to reduce by half because that's currently the law. It says there's a sunset. So we have to be aware of what the estate tax is. Maybe it's a great idea to be doing some transfers right now to take advantage of a gift, but maybe we want to wait it out until after we see what Congress does this year. Or if you have property in a bypass trust, we got to consider the estate tax savings there because it's been appreciating without impact to estate taxes. That was the whole purpose back then. It might be better to keep it in the bypass trust, despite everything, all things considered equal. So it requires a detailed tax analysis here. But here are the possible solutions after we do that tax analysis. Okay, here's some things that we can do. And the solutions, number one, I talked about for estates, got to file those exclusion forms immediately and do it correctly. You can do grantee transfers, i.e. the quitclaim deed in select situations, again, only after there's been a good analysis by a professional here. And that might be a great way to go. Another way to go is something that we're calling a Prop 13 trust. Right, this is something we're naming Prop 13 trust. It's not a law that created it. Prop 19 doesn't say anything about Prop 13 trust. We're just human beings, and we want to place names on things to identify them. So we're identifying this type of irrevocable trust as a Prop 13 trust. It's a special standalone trust that your clients can create to basically shelter and protect those properties and pass them to children or grandchildren in order to trigger the change of ownership to get the exclusion forms filed and preserve the Prop 58-193 exclusions so that when they pass, that will not trigger a property tax reassessment. So great tool right now for that savings. Another benefit there is that it also preserves the step up in basis. So they get to have it both ways with these types of irrevocable trusts as we're designing them. Now, they can't just be any irrevocable trust. It has to be very, very designed very special, right? So these are particular conditions. You got to work with somebody that is an experienced attorney, particularly those in elder law are very familiar with the trusts. Here, people that have a good tax planning practice will be familiar with these types of trusts here because if you do it wrong, it's not going to work. And like I said, the last thing you want to avoid property tax for your kids, the increase, but you inadvertently increase their capital gains tax. That's not going to be any fun for them. It's going to be more expensive. So in order to do it right, you got to use a professional that knows what they're doing. So there is a possibility. Now, those three taxes, we can get the 2 out of 3. It's the best we can do. We can't get all 3. So there's always going to be trade-offs. So estate tax is going to be a trade-off with some of the other 2 taxes. That's part of the conversation. But at the end of the day, the goal is to have a tax savings for your children or grandchildren. It just might be that the greater tax savings is with one of the other taxes and not the increase in the property tax. So either that's going to be a gift or a sale to the irrevocable trust. And whatever the solution is very nuanced, so it's best dealt with analysis on a case-by-case basis as to which you choose. Petition the court for modification of a bypass trust. You have a bypass trust, you got to get into court. Problem is, courts are hard to get into right now. So this might not be a viable solution. It is for our clients. We work with other colleagues to make this happen. We're currently doing that for clients, but there is a very, very small window here. Even to do it on a fast track is a very small window. So your clients need to act right away. So maybe put on the top of your list clients that have those AB trusts. Or at the end of the day, do nothing, right? You can go through the analysis and then nothing needs to be done, or you don't want to do anything. But at least you had the analysis, right? And the clients had the analysis and they feel comfortable. So they're not sitting there going, I have no idea if this thing's going to hurt me. I didn't do my homework and I'm just going to go blind and hope for the best. They have that assurance that doing nothing is the best approach. So how do we get there? How do we get to figuring out what's the best approach? Well, what we're offering is a Prop 19 strategy meeting. So we've carved out some extra time in the next 7 weeks to have these Prop 19 strategy meetings. We are not taking any meetings beyond February 2nd because in and of that in and of itself, there's going to be a rush on top of that. Because we need the lead time to be able to have the meeting, do the analysis, and start putting the plan in place if there is a solution that needs to be had. So for people that are doing something, you need some lead time, particularly if it's going to involve doing a court modification. We got to get that started now. So we've made some extra time. This is how your clients can sign up for a meeting with us. You can call the office, talk to Carolyn. She'd be happy to schedule. You could just click here on this website and I'll take you there to our online calendar and you can schedule yourself with either myself or Hannah. And we'll review your client's estate plan. We'll analyze the tax impacts to them of Prop 19. We'll recommend the solutions and all that for a small $500 consultation fee. So this gives your clients great peace of mind. We're having these meetings. We've been having these meetings. They're very productive. And some clients, like I said, do nothing is the result, and they have that peace of mind. Most other clients, however, there's the solutions that we're moving on and doing. So happy to meet with your clients. Really appreciate the opportunity to present to you today and get this information. I'm going to try to have a follow-up in the new year, kind of take a pause and wait for the Board of Equalization to catch up. Again, they just issued a letter on Friday that really doesn't say very much. I shared with you in my meeting, in our webinar today, what they've shared about family home. That was kind of the big one, and the new value test to kind of get assurance on that. Other than that, a lot of other unanswered questions. So there'll be more to come for sure. So keep your eye out. And so now, time for some good questions that you might have. So we'll have one from one watcher here who I know is a realtor, said, "Do you recommend everyone file a homestead?" Everyone should file a homestead. You're going to save $70, number one. So that's going to be helpful, and you're going to need to file it for this purpose later. So if in order for your children to take advantage of the February 16th and later, the Prop 19, you want your children to take advantage of the very small principal residence exclusion, then it has to be your principal residence. So the best way to prove that, if you claim it as your homestead. So definitely claim your principal residence as your homestead. So does property need to be gifted or sold to Prop 13 trust before February 16th? Yes. So the transfer, so gift or sale or inheritance, so the transfer has to occur prior to February 16th, no matter what you're doing. So if you're doing the transfer to this Prop 13 trust that I'm talking about, or you're doing the quitclaim deed, those transfers have to have occurred prior to February 16th. And when I say they occurred, it's unclear whether occurred means the date of the transfer. So if you're deeding something, the date you signed the grant deed, or if it's the date of the recording of the grant deed and the filing of the claim form with the assessor's office. We just don't know what the measure is going to be. It seems like it'll be the date of the transfer, but I don't want to take that gambit for clients. We're very conservative. So we want the transfer and the filing of the paperwork to be recorded and received by the necessary county assessor and recorder's office to have that assurance. So that's why we need to act quickly, because there's delays in COVID right now. You can't go up to the front desk at the recorder's office. Fortunately, we have available electronic recording that our office is using. So that speeds up the process than if you try to do it on your own. Question about the QPERTs. Is there any way to retroactively put property in a QPERT after February 16th? I think that question may be referring to kind of undoing the QPERT, or maybe putting it back into the QPERT after February 16th. You're not going to, the QPERT planning is going to be very disrupted because of Prop 19. All right. So because if you undo the QPERT, or you don't have a QPERT, for example, a transfer of the property into the QPERT later is going to cause a change of ownership after February 16th, 2021. And we know what happens. Property tax reassessment when the children fully vest the interest at the end of the term of the QPERT. So QPERTs are going to become less in vogue. Of course, if the estate tax law changes, they might come back, because then we said, well, we have to look at the lesser of two evils. Yes, we're going to have to take a hit on the property tax, but the estate tax savings is huge. So for at least right now, with the estate tax exemption levels are 11.58 and higher for per person, the QPERTs are going to become less in vogue here because of the property tax ramifications. We're just going to see that. So that's my my thoughts on it, what I think. Other questions? I'm just going to cycle through here. So those are some great questions. If you have any other questions, you certainly can reach out to me. Here's my email address, my phone number. I could just tell you in this time right now, particularly end of the year now with Prop 19, questions emailed to me will get a faster response because I'm in meetings all day, particularly talking about this issue. So you can schedule online with for your clients. There again is our online schedule link. Check out our website. We got some great resources on there for those of you who haven't availed yourself of those resources, from Prop 19 to other things that are important to your clients. We're happy to assist. And really, thank you again for being very great partners. I will be sending out a recording of this webinar to you because there's a lot of information here to unpack. And so I'd like you to have a chance to review it. I'll send you the slides as well, because I just want you to have the information. Sure, I put it together. I suppose it's proprietary, but I want you to have the information. It's very, very important that your clients act. I don't expect you to retain it all in your head right now, this early in the morning. And for me, having to talk quickly to make it to just a little over an hour. So thank you very much for people who have attended. And I hope you guys have a wonderful holiday season and a happy new year. And here's to a much better, safer 2021. And I look forward to the opportunity to continue to partner with you in the new year.